And Deputy Potts, how are you?
Mark, how you doing, sir?
I'm doing well. Good morning, Mr. Florio. How are you?
Good morning, Your Honor. How are you doing?
I'm doing well. And ma'am, I apologize. I apologize if I mispronounced your name. Hold on. Okay. Is it Miss Newt? Nutch?
No, Noosh.
Noosh.
Lawyers. Somebody's got lawyers.
Okay, Miss Noosh, we're going to deal with you first. And I understand your client needs an interpreter.
That's correct, Your Honor.
Okay, so we have Miss Tolles here. And the individual we're going to deal with first, his name is Mr. Fleets Ochoa. And I'm gonna do him first. I'm not gonna need to read the script to him because his case is different. So if you would put Mr. Fleets Ochoa on the camera.
Your Honor, good morning.
Good morning. How are you?
Fine.
Mr. Fleets Ochoa, can you hear and understand the interpreter?
Hola, señor Fleets Ochoa. ¿Puede usted oír y entender a la intérprete? Yes.
Normally, I would speak to you directly, but since you have a lawyer here, I'm going to speak to your lawyer.
Normalmente hablaría con usted directamente, pero como su abogado está aquí presente, voy a hablar con su abogada.
Any discussion that we have here is not private, so please don't say anything that you would not want the whole world to know.
Cualquier cosa que hablamos aquí no es privado, así que por favor no diga nada que usted no quiere que yo como juez escuche.
So, Ms. Nuches, I received a phone call yesterday afternoon that your client had not had first appearance.
Entonces, señora Nuches, yo recibí una llamada ayer en la tarde que su cliente no había tenido su audiencia de la comparecencia inicial.
That's correct, Your Honor. Mr. Fletes was arrested on or about March 31st of 2021.
Sí, es cierto, su señoría. Al señor Fletches lo detuvieron alrededor del 31 de marzo de 2021.
He has been in custody for over a month and a half without a first appearance hearing so far.
Ha pasado un mes y medio sin una comparecencia inicial hasta la fecha.
So we would like to move the court to release Mr. Fletes immediately pursuant to OTGA 17426.
Entonces solicitamos que, señor juez, usted deje en libertad al señor Fletches de inmediato, según dispone el Código de Georgia 17-4-26.
I asked for him to be placed on this calendar immediately because I wanted to address this issue.
Yo pedí que lo programara para esta lista de causas de inmediato para resolver este asunto.
When I went back and researched the issue, it appears that I had initially set a bond for him on both charges on March 31st.
Cuando yo fui a investigar el asunto, parece que inicialmente le impuse fianza para las dos acusaciones el 31 de marzo de 2021.
And that process normally happens early in the morning before the hearing even starts.
Y ese proceso normalmente sucede temprano antes de que comience la audiencia.
I was informed that Mr. Fletes was in the hospital.
Me informaron que el señor Fletches estaba hospitalizado.
And that he had surgery.
Y que lo habían sometido a una cirugía.
Do you know what he was in the hospital for?
¿Sabe por qué estaba en el hospital?
My understanding is that it was based on an injury he suffered on one of his shoulders upon arrest.
Según yo entiendo, se basaba la cirugía en una lesión que él sufrió en el hombro al estar detenido.
When I discovered that he was in a hospital, I asked for him to be placed on my calendar for April 1st.
Cuando yo descubrí que estaba hospitalizado, yo pedí que lo programara para, I'm sorry, Your Honor, if I may ask, was that April 31st?
April 1st.
I'm sorry, Your Honor. Yo pedí que lo programara para una audiencia el 1 de abril.
I was notified at that point that he was still in the hospital.
Pero me notificaron en ese momento que seguía en el hospital.
So I entered an order on April 1st for him to be brought before me as soon as he was medically able.
Entonces yo dispuse una orden el 1 de abril para que lo hicieron pasar delante de mí en audiencia en cuanto estaba en condición médica para hacerlo.
And apparently for some reason that did not happen.
Y aparentemente por alguna razón eso no sucedió.
Mr. Fletes Ochoa is entitled to be released.
Pero el señor Fletches Ochoa sí cumple los requisitos para ser liberado.
Because of the length of time that he's spent in jail, I'm going to dismiss his charges today.
Debido al tiempo que él ha pasado detenido en la cárcel, yo voy a desestimar las acusaciones de su contra hoy mismo.
The solicitor, of course, can draw up an accusation if they so choose.
Claro, los fiscales pueden redactar una acusación si así desean hacerlo.
That decision is out of my hands,
Esta decisión está fuera de mis manos.
but it's ridiculous that he sat in jail this amount of time.
Pero es una ridiculez que él ha pasado en la cárcel por tanto tiempo.
So I'm dismissing his charges, and I do apologize, sir.
Entonces yo le voy a desestimar las acusaciones, señor, y le pido disculpas.
Ma'am, do you have anything else to address with the court?
Señora licenciada, ¿hay otro tema que quiera tocar conmigo?
No, Your Honor, we just want to thank the court for, your honesty and for bringing this case before the court as soon as possible. And we do appreciate you allowing Mr. Fletes Ochoa be released today.
No, su señoría, solamente queremos agradecer su sinceridad y que usted ha pedido que él tuviera su audiencia lo más pronto posible y que ahora lo está dejando en libertad.
So, sir, I will be sending this order over to the jail today for your release.
Entonces, señor, voy a enviar esa orden hoy mismo a la cárcel para que lo dejen en libertad.
And you will be released.
Y quedará liberado.
Anything else?
¿Algo más? No.
Okay.
No.
Yes, ma'am.
No, Your Honor, I'm sorry. Not on our part. Thank you.
No
Okay,
sé, su señoría, de parte de nuestra, nada más adicional.
You're free to go, and Mr. Fletes Ochoa, you're free to go back, sir.
Bueno, el licenciado ya se puede retirar y usted también, señor Fletches Ochoa.
Thank you, Your Honor.
Thank you. Do we have anyone else that needs the services of the interpreter?
Negative, Your Honor.
Okay, I see you shaking your head no, Deputy Cox.
No, sir.
Okay. Ms. Tolles, thank you as always for your service, and you are free to go.
All right, thank you. Everyone have a great day.
You too. Mr. Florio, I'm going to come to you after I read the script, and we'll start with your client. Mr. Florio's client is a Miss, is it Epps?
Yes, ma'am. Ms. Esquapina.
Esquapina. Okay.
Yes, sir.
Okay.
Look, Your Honor, what's her name? Esquipina, first name Samara.
Yes.
She's gonna be in medical. They put her in medical this morning on suicide watch. So I was gonna ask the court to put her on the schedule for tomorrow. As soon as we got to go get her, they was placing her on suicide watch.
Okay. I'm
Judge, is there, I mean, I understand she can be a bit dramatic. And her husband in the past has had a not so great relationship with the sheriff's office. I don't know if that's the reason why she's been assigned. I mean, I've known this lady for years and she's not suicidal.
Your Honor, what I can do is after you read, I'm not telling you what to do, Your Honor. But after you read the script and you go over the script, after we finish the females, I can go to medical and try to just set up a monitor for her, just for her, and
Let's
do a first appearance like that.
let's do that since she has her lawyer here.
Okay.
We can deal with it all at one time.
Yes, sir. We can do that.
Okay,
Thank you, Your Honor.
you're welcome. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I am not here to conduct a trial of your case or to take a plea in your case. I am here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you if your case goes to trial. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: the right to the presumption of innocence, the right to indictment by a grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you, the right to compel the attendance of witnesses to testify on your behalf, the right to testify on your own behalf or offer evidence in your own defense, the right to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond and fees in cash to the sheriff's office. The sheriff's office will hold the cash and return it at the end of the case. If you use a commercial bonding company, someone will have to pay a fee to the company for their service. The fee will not be returned. I don't know what fee will be charged, but it is usually based on a percentage of the bond. Finally, if you use property to post a bond, the property will need to have a net equity at least 3 times the total amount of the bond. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. This special condition will be provided to you on a separate form. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, I need everyone to raise your right hand, please. Do you swear or affirm that any statements you make during this proceeding will be the truth, the whole truth, so help you God?
Yeah.
Okay, let's start with Miss Bale.
Put your hand down.
Miss Bale, you're charged with 1 count of interference with custody and 1 count of kidnapping. I've set a bond of $5,000 for the interference with custody, but I'm unable to set bond on the kidnapping charge because of a prior conviction for aggravated assault. I've placed a stay away provision on this bond to stay away from Tanya Bell. I am going to give you a preliminary hearing date of July 7th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. I'm also setting a bond hearing date for July 9th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, I would like to see that as well.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I'm just trying to figure out, my probation puts a hold on me as well. She lets me out 3 days ago at a military address that I didn't even supposed to be at. I had a warrant there.
You got a question for the judge?
So I'm trying to figure out where I'm gonna do this probation and to see my kid. It's hard for me.
Talk to your lawyer or talk to your probation officer. Okay.
Like I don't understand a lot. You say when I have my next hearing.
So you have a preliminary hearing date that's set for July 7th at 8:30 in the morning, and currently that'll be by Zoom. You also have a bond hearing date that's set for July 9th, and that's also at 8:30 in the morning. I've appointed a lawyer to represent you. The lawyer is the person that can navigate those waters as it relates to your probation officer and could possibly get the district attorney to agree to a consent bond.
I just want visitation rights.
The judge, he ain't got nothing to do with visitation of your child.
Okay.
Yes, ma'am. I have, you can file the appropriate paperwork in the appropriate court. Okay.
Fine, Judge.
All right. You're free to go back, ma'am.
Barry,
Next is Miss,
Barry.
come on. All right. Barry, next is Miss
Are you the
Barry.
last one?
Right there. Come on, Miss Barry. Come on, Miss Barry.
Miss Berry, ma'am, you've been charged with 1 count of battery. I've set the bond at $5,000. Do you believe you can post that bond, ma'am?
I'm sorry?
I've set a bond at $5,000. Do you believe you can post that bond, ma'am?
I will have to see. I'm not sure.
Okay. I've also placed a stay away provision on the bond to stay away from a Billy Bethea. Do you understand that?
Yes.
You're going to have a preliminary hearing date set for July 6th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Only my bond is set. Is no way it could be lowered by any chance, so I can get home to my son.
That's the lowest amount that I set for battery. Okay. Anything else, ma'am?
No, thank you.
Okay, you're free to go back.
You gotta sit down. Make sure you get something to eat before you leave. Next is Miss Dixon.
Ms. Dixon, you're charged with 2 driving-related offenses. One is driving on a suspended license. The second is driving a vehicle with an expired tag. The bonds for these are set by schedule, which means they're automatically set. So you're gonna have a total bond set at $2,000. Do you believe you can post that bond?
No, is the $2,000 for both of the charges?
Yes, 1,500 for the driving on a suspended license and 500 for the driving a vehicle with an expired tag.
I'm not gonna, if I'm not able to post bond, I don't have family out here, just me and my children. And what will happen if I'm not able to post the bond?
So these are low level offenses. My understanding is that upon having a lawyer appointed, that they'll put you on the next Monday calendar to deal with this.
Yeah.
Okay,
So do you want me to see if you qualify for the appointment of a lawyer?
yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, just so I can be sure. So last night it was 2,500, but right now it's just 2,000.
So there are fees that are added. The sheriff's department is required by law to add fees, and I don't have access to the schedule. So if they told you it was $2,500, then that's going to be the final amount when the fees are added.
Okay, so you didn't lower it. It's the same, the bond is gonna be the same it was last night.
Yes, ma'am.
Okay. And that's the lowest for driving without no license?
So these bonds are set by schedule, which means a group of judges sat down and decided what bonds are appropriate for certain offenses. So this is something that you could have bonded out yesterday and gone home and not have to sit in jail overnight to see me. I would encourage you to contact the bonding companies because you did.
Yes, sir.
And did they say, you said you're not from here, so did they say that there's something related to?
All the ones I called, I have a sister, but she's in Jamaica. She lives in Georgia and she's a Georgia resident. She have a job, but she's in Jamaica. So the only one that let her do everything over online, they stopped responding. She sent all of her information in, even, and it says that it's being looked at and they'll get back into her, but that was yesterday at 6 o'clock.
So is all your family in Jamaica?
No, all my family is in Michigan. Just me and the kids here. I have one sister that lives here, but she's in Jamaica.
I'll make a suggestion to you. If you have family members that can help you in Michigan, contact them because sometimes bonding companies will work together so they could make the arrangements there with the bonding company for your release. And then that bonding company will contact the bonding company here.
Okay.
So there are ways for this to work. Don't just resign yourself that you're gonna sit here because you don't have to.
Okay.
Okay.
Mhm.
All right, ma'am, you're free to go back.
Next is Ms. Epps.
Ms. Epps, you're charged with 1 count of criminal trespass as a misdemeanor and 1 count of possession of cocaine. I've set your total bond at $4,500. Do you believe you can post that bond, ma'am?
I believe I can.
Okay, you're gonna have a preliminary hearing date set for July 7th because the possession of cocaine is a felony offense. It's gonna be set at July 7th at 8:30 in the morning, but that date will get waived upon your bonding out and you'll get a new court date in the mail.
I don't think I'll be able to bond out, actually.
Okay. Well, I will say the same thing I just told the other young lady. Just try. Okay.
Okay.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you.
Thank you so much.
Do you have any questions for me?
No, I do not.
Okay, ma'am, you're free to go back.
Thank you.
Next is Ms. Foster.
Ms. Foster, ma'am, you're charged with one count of crossing the guard line with drugs in your possession, and one count of violation of the Georgia Controlled Substance Act. It looks like they tried to delete that charge, but I have dismissed it anyway. So you're just going to have the one count of possession of I think it was cocaine.
It was methamphetamine.
Methamphetamine. The bond is going to be set at $3,000. Do you believe you can post that bond?
Yes. Or
Okay.
maybe, I'm not sure, I haven't tried.
Okay. You're going to have a preliminary hearing date set for July 7th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay.
I also have a probation here. Does that not have the hold?
I don't know if probation has placed a hold on you yet. I am going to appoint a lawyer to represent you because you do qualify. If they have placed a hold on you, the jail will know, and so you can ask the people that are in the bonding area
Okay,
whether there's been a hold placed on you.
okay.
Any other questions, ma'am?
No, sir.
Okay, you're free to go back.
Thank you.
Next is Ms. Harper.
Ms. Harper, you've been charged with one count of possession of marijuana less than an ounce, one count of giving a false name, address, or date of birth, and one count of obstructing an officer. I've dismissed the obstructing an officer charge, but you're going to have a total bond set at $2,500 on the other two counts. Do you believe you can post that bond?
Yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for July 6th at 8:30 in the morning, but that date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Nope, I'm
You're
fine.
going to hire your own lawyer?
Do I need a lawyer? Because my aunt already on I can just get bailed out, but I don't.
Oh, okay. So I always tell everyone, it's not my job to shove a lawyer down your throat. If you qualify and you want one, it's my duty to appoint one. You can represent yourself, you can hire your own lawyer, or you can go with an appointed lawyer. It's your choice.
Okay, so right now I'm gonna just hold off on that.
Okay.
Okay, yeah.
Any other questions, ma'am?
Is this a cash bond?
Cash, commercial, or property.
Okay, all right, thank you. No, that's it.
You're okay. You're free to go back.
All right.
Next would be Ms. Lackley, but she's our future, so I guess do you want to do her last or?
Yes, let's do her last.
Okay, so Ms. Nichols,
Do you have her her waiver?
I do, Your Honor.
Okay. I'm sorry. What's your name, ma'am?
LaCarla Nicholas.
Okay. Okay, ma'am, you've been charged with one count of criminal trespass, damage to property. The bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
There's also going to be a stay away provision on the bond to stay away from a Wade Coleman. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Excuse me, do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Next is Oliver.
Ms. Oliver, you've been charged with 1 count of simple assault, 1 count of cruelty to children in the 3rd degree, 1 count of criminal damage to property in the 2nd degree, and 1 count of simple battery. The criminal damage to property in the 2nd degree is being drawn up as a felony charge. You're going to have a total bond set at $15,000. Do you believe you can post that bond?
Yes, sir.
You're going to have a stay away provision on the bond to stay away from a Bakari boat right. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for July 7th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, ma'am. I am going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Next is Miss Banks. Spades.
Okay. Ma'am, you're here on a contempt of court. You're shaking your head.
Sir, Your Honor, I was told that I can go to the house as long as I'm escorted by a police officer to get my high blood pressure medicine and my clothes. I've been out of that house for 2 weeks. I went there with an officer that day, that morning, and he handed me, the officer from Mr. Reed, a pill bottle, but it wasn't my pills. I asked the officer, could he hand it back to Mr. Reed? I left without anything, no clothes, no nothing. The officer talked with him for about a half an hour. I came over here because I was called from the sheriff's office to come over here. They served me with some eviction papers, something else, and then told me to put my hands behind my back, and I didn't understand why. And he said that I violated the order, but I didn't violate the order because I was told as long as I'm being escorted, I can go. And I did what I was supposed to do. I went to Sector 4 police station. They wrote up the report. I videotaped the whole thing so I wouldn't be in trouble.
So, do you have the name of the officer that appeared there with you?
Yes, his name is Officer Billingsley. So that's Billingsslea. I called from Clayton. I called from Riverdale. I was on Homeward Bound because I couldn't go on the street where I lived at on Creekwood Court. I couldn't go there, so I sat on Homeward Bound and I waited for the police to come. And then he escorted me around the corner. He went inside, he knocked on the door, and Mr. Reed answered it probably like after like, I don't know, 4 or 5 knocks. And they stood there discussing for about, I said half an hour. And then I never got anything and I left. I didn't do anything.
So it says here, and the reason I'm having this discussion with you is because the way that this charge is written up as a violation of bond,
Yes, sir.
from a due process standpoint, you're entitled to notice and opportunity to be heard, which means you're entitled to be told, this is what the issue is. We're going to set this down for a particular date in order for there to be a hearing.
Yes, sir.
It says that this was recorded, but there's a different officer. Someone from the sheriff's department is the one that got this. I do recall the officer Billingsley.
Yes, sir. That's who went with me to the property. no other sheriff was there. Derek, Mr. Reed was supposed to meet on Monday, the 17th. I'm sorry.
Okay, this is what I'm going to do, ma'am. I am going to enter an order for your release today, but I'm going to have this set down for a hearing.
Thank you so much.
And you're going to have to show up at that hearing. I would advise to have a lawyer present.
Yes, sir.
And I'm going to place it on a preliminary hearing calendar. Do you have an address now that you can be served? And I'm not asking you to tell me this because this is over the internet and I don't need people come knocking on your door. But do you have an address?
No, I was actually staying at a hotel, but I do have a sister house down here that I can stay there to get served. I mean, I do have some place.
Okay. Okay. All right. Ma'am, this is what I'm going to do. I'm going to place you on tomorrow's calendar because this is something that if this is what they're alleging, this really is an aggravated stalking. This is not a violation of bond. So give me 1 second. Well, I'm going to place you on tomorrow's calendar. I'm going to do a continuous order and I'm going to get this straightened out. Okay.
Yes, sir.
Okay. Give me 1 second.
God.
Okay, I'm sorry for the confusion. What I'm going to do, ma'am, is I'm going to continue this case over to my calendar in the morning.
Yes, sir.
And I'm going to check into this
Yes,
and
sir.
see what exactly is going on. Okay?
Yes, sir.
All right, ma'am, you're free to go back.
Thank you.
Okay, Your Honor, next is going to be
Ms. Thomas?
Thomas.
Ms. Thomas, ma'am, you've been charged with one count of driving on the wrong side of the road, one count of giving false name, address, or date of birth, and one count of driving a vehicle without a license. I've set a total bond at $2,500. Do you believe you can post that bond, ma'am?
Yes.
Okay. You're going to have a preliminary hearing date that's going to be set for July 6th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah, I guess so.
Again, I mean, I'm not here to throw a lawyer down your throat, ma'am. If you don't want one, I won't appoint one. So is it yes or no? No. Okay. Any questions, ma'am?
So once I post the bail, I can go home.
Would you repeat that?
Just speak up a little bit.
Once I post my bail, can I go home?
Yes, ma'am.
So if I go through the bails, bondsmen or whatever like that, it would have to pay the whole 2,000, or is it like a percentage?
Okay, so if you go through a bail bondsman, they will charge you a fee, which is usually based upon a percentage of the bond. I don't know what fee that they would charge. You would have to contact them directly, tell them your name, your charges, and your bond amount, and then they will give you that information.
And it's 2,000, you said?
Yes, ma'am.
Okay.
Anything else, ma'am?
No, thank you.
Okay, you're free to go back.
Next, it was an add-on, Miss Jones Taylor.
Okay.
Just have a seat. Just have a seat.
Okay, Miss Jones Taylor. Okay. I just had, oh, here we go. Ma'am, you've been charged with one count of criminal damage to property in the second degree. This is being charged as a felony. I've set the bond at $3,000. Do you believe you can post this bond?
Yes, I believe so.
Okay, I'm also gonna place a stay away provision on the bond to stay away from Robert Jones. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for July 7th at 8:30 in the morning, but that date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. All right, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, no questions.
Okay, you're free to go back, ma'am.
Thank you.
You're welcome.
Last is Miss Leckley.
And we also,
Yeah, I'm gonna go get her after we finish.
okay, so after we're done with Miss Lackey, I'll just switch over to the males and you just let me know when you are ready and we'll start with Mr. Florio.
Yes, sir.
Okay, so ma'am, all of the rights and privileges that I explained in the beginning, they apply to you in this situation, but you're in sort of a little bit of a different boat. You're not here because of any charges pending in Clayton County. You're here because you're what's called a fugitive from justice. And what that basically means is that another state wants us to hold you until they can come and get you. And you're being held because of an alleged warrant out of Tuscaloosa County, Alabama, for failure to appear on a dangerous drugs charge. They indicated that they will extradite, and what that means is that they said that they're going to come and get you. So you have up to a 60-day period after the warrants are issued for them to come and get you. You can also demand for there to be a hearing. And so what I mean by that is this, is that if you believe that you're not the person named in this warrant, or that these charges are not valid, you can demand to have a hearing. And sometime within the next 30 days, you'll have a hearing before a judge of this court. And the judge of this court will not be trying to determine whether you're innocent or guilty. They're just going to determine whether you are the person named in the warrant and whether these charges are valid. If they make that determination, they will sign off on the writ for you to be extradited, meaning sent back to Alabama, and then that 60-day clock will begin to run. You also have the right to waive that hearing. And what that means is that you can make a determination today that you do believe you are the person named in the warrant, and you do believe that these charges are valid. And you can say, look, I'm going to waive that hearing. I want them to come and get me. If you were to sign the waiver, Alabama has an initial period of 30 days to come and get you. If they don't come and get you within the 30-day period, they will get a call from the sheriff's department here saying, hey, do you want this person? And they will either say, hey, we don't want her anymore, or, well, can we get a 30-day extension? If at the end of that extension period, they don't come and get you, the sheriff's department will contact them again, and most likely the sheriff's department here will release you. If you get released, that does not mean the warrant has been dismissed. It just means that Tuscaloosa didn't comply with their end of the bargain. If you are released here and the warrant is still pending, you can walk out the front door. 5 minutes later, you encounter a police officer. That police officer runs your information, the warrant pops up, and this process starts all over again. Are you with me?
Yes, sir.
Do you have any questions at this point?
No, sir, I do not.
Okay. Have you had an opportunity to think about this?
Yes, sir.
Do you know whether you want to have the hearing, or whether you want to do the waiver, or do you need?
I'm just gonna go ahead and sign.
Okay. So they're going to present you with a copy of the waiver. You're going to sign it. They're going to give it to me today. I'm going to sign it, and then the clock will start to run today.
All of it the same.
All right.
Anything?
No, all of them the same thing.
All right.
Okay. Once she signs the waiver, she can be free to go back. I'm going to switch over to the mail side, and just let me know when you're ready with Miss Esquia.
Yes, sir. Yes,
Thank
sir.
you.
You're welcome, ma'am. Okay, we have Mr. Albright.
Yes, sir.
Mr. Albright, you're charged with one count of driving a vehicle with an improper tag or an improper display of a tag, violation of Georgia Controlled Substance Act, which is possession of 2 pills they believe to be ecstasy, possession of a weapon during the commission of a crime, and driving a vehicle without a valid license. You're going to have a total bond set at $6,500. Do you believe you can post that bond, sir?
Yes, sir.
Okay, your preliminary hearing date is going to be set for July 7th at 8:30 in the morning. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify. Mr. Albright, I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Not at all.
Okay, you're free to go back.
Mr. Brunson?
Mr. Brunson, you're charged with 1 count of possession of firearm by a convicted felon and 1 count of obstructing or hindering law enforcement. I've set a total bond at $7,000. Do you believe you can post that bond?
Yes, sir.
You're going to have a preliminary hearing date set for July 7th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Is it your intent to hire your own lawyer?
Nah, I'm all right, sir. I don't need no lawyer.
Okay. Do you have any questions of me?
Nah, sir. I'm all right. I just say thank you for that. All right.
Okay, you're free to go back, sir.
Bello?
Yes, sir.
Hey.
Mr. Bello, you're charged with 1 count of driving under the influence and 1 count of improper lane change. I'm going to set the bond at $5,000 on the driving under the influence count and $500 for the improper lane change. So you're going to have a total bond of $5,500. Do you believe you can post that bond, sir?
Yes, sir.
You're going to have a preliminary hearing date that's going to be set for July 6th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Thank you, sir.
You're welcome.
Mr. Benitez?
Mr. Benitez, you're charged with 1 count of possession of marijuana less than an ounce and 1 count of loitering or prowling. The bond for both of these offenses is set by schedule, which means they're automatically set. So you're going to have a total bond set at $2,500, but there will be fees added to this bond by the sheriff, to every bond by the sheriff's department. Do you believe you can post this bond, sir?
Yes, sir. May I ask what the total is?
I don't have access to that schedule, but I believe it'll be close to 3,000.
Okay.
Yeah. You're going to have a preliminary hearing date set for July 6th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. I also have another question. I mean, if somebody—
Hold on 1 second. Hold on 1 second. Hold on 1 second. You do qualify. I'm going to appoint a lawyer to represent you. Now, what's your question, sir?
Oh, my question was that does the bond be paid up front before the fees, or do the fees have to be included for the bond to be paid?
The fees will be added automatically, well, not automatically, but they will be added by the people who do the bonding paperwork in the sheriff's department. So you'll know the amount. Once, like, for example, because these bonds are set by schedule, you could contact the bonding company right now and they'll know exactly what the total amount will be. You don't have to wait until you get notice because your bonds have been set by schedule. So you can, when you get the chance to use the phone, you can just contact the bonding company and let them know, and they'll make those arrangements. And so once the paperwork gets over there today, you'll be ready to go.
All right, thank you.
Okay, you're free to go back.
Have a good day, sir. Mr. Colley?
Okay.
Okay, is it Mr. Coley?
Yes, sir.
You're charged with 1 count of family violence battery. I've set the bond at $5,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond to stay away from a Chad Coley. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Thank you. Have a good one.
You too.
Mr. Carter?
Mr. Carter, sir, you're charged with one count of terroristic threats or acts, one count of disorderly conduct, and one count of possession of marijuana less than an ounce. I'm going to set a total bond in this case at $7,000. Do you believe you can post that bond? I'm sorry, sir.
No, sir.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
What's 7,000? I gotta pay that off? I gotta pay all that? Or is it 700?
Okay. So you're going to have an opportunity to post your bond by cash, commercial, or property. You can pay the entire amount in cash to the sheriff's department. They'll hold it for you and they'll return it to you when your case is over. You can go through a bonding company where you pay a percentage. I don't know what the percentage will be. You'll have to contact the bonding companies. Whatever fee you pay to them, you will not get back. The third option is property. If you have real estate in this county that has a net equity of at least $25,000, it appears in your case, you can put the property up. They'll put a lien on the property. And when the case is over, they'll take the lien off.
My bill is $7,000. Huh? My bill is $7,000?
Yes, sir.
Okay, what? I just
Pick
want
up your, pick up the thing. Put it on there.
Okay,
And that's your
$7,000.
You can bust it.
My
Okay,
bill
I'm gonna start over, Mr. Carter, okay? You've been charged with terroristic threats or acts. The bond for that is $4,000. You've been charged with disorderly conduct. The bond for that is $1,500. You've been charged with possession of marijuana less than an ounce. The bond for that is $1,500. That totals up to $7,000. Do you believe you can post that bond, sir?
You want me to pay $7,000?
You can stay in.
I'm not understanding, sir. Please.
Sir,
I just want to understand.
Then
I'm sorry.
Listen to me real quick.
Mr.
Listen.
No.
Listen.
Mr. Carter, the allegation is that you told a store clerk that you will slit her throat. That's where the $4,000 bond comes from. They said that you acted in a violent and tumultuous manner towards the store clerk. That's where the disorderly conduct comes from. When you were arrested by the police, you had a book bag that had less than an ounce of marijuana in it. That's where that charge came from. I can appoint you a lawyer and the lawyer can fight these charges.
Yeah, do that. I mean, I can pay the bill.
So Mr. Carter,
I want my bill.
you're wasting your time and everybody else's time. Because the longer we sit here and have this conversation, the longer you're going to be sitting in jail. So if you want to get out of jail, sir, let's work together, okay?
Okay.
Your preliminary hearing date is going to be set for July 7th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. You do qualify for the appointment of a lawyer, so I'm appointing a lawyer to represent you. Do you have any more questions for me, Mr. Carter?
You said my court date is July 7th.
But that date will get waived upon your bonding out, and you'll get a new court date in the mail. Okay, you're free to go back.
Mr. Gordon?
Mr. King.
Oh, Mr. Kane, I'm sorry.
I was going to say what happened to Mr. Kane. Mr. Kane, sir, you're charged with violation of Georgia Controlled Substance Act, possession of less than an ounce of methamphetamine, possession of less than an ounce of marijuana, use or possession of drug-related objects, possession of the methamphetamine with the intent to distribute, loitering or prowling, and another possession, it looks like, of marijuana with the intent to distribute. So you're going to have a total bond, sir. Set at $14,500. Do you believe you can post that bond? You're going to have a preliminary hearing date set for July 7th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Thank you.
Mr. Gordon?
Mr. Gordon, sir, you're charged with 1 count of battery. The bond is going to be set at $5,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond to stay away from a Joseph Buchanan. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Gordon. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back.
Thank you.
You're
Mr.
welcome.
Jared?
Are you Mr. Harrison?
No, Mr. Jared.
Mr. Jarrett, okay.
Yes, sir.
I'm sorry. Let's see. Mr. Jarrett, you're charged with 1 count of simple assault and 1 count of terroristic threats or acts. I've set a total bond at $9,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond to stay away from a Yonika Fagan. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Jarrett. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back.
Mr. Jeremiah Jones?
No, sir. Yes.
Did we lose Mr. Harrison? Mr. Jones, sir, you're charged with improper solicitation of money on a roadway and use or possession of drug-related object. I've set a total bond of $2,500. Do you believe you can post that bond?
$2,500 for both charges?
There's $1,000 for the improper solicitation of money and $1,500 for the use or possession of drug-related objects.
All right, thank you. When is my preliminary? My next court
Your
date?
preliminary hearing date is going to be set for July 6th at 8:30 in the morning. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Please, please do. Yes, sir.
Okay.
And it's been a while, man. So, but thank you. I'll tell you.
Okay, Mr. Jones, you do qualify. And just to be certain, you are Jeremiah Jones, correct? Okay, Mr. Jones, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I do, about, my next court date, because, the description, whatever the officer wrote, I don't know how severe it was. I really wasn't doing nothing. I really was just.
Okay.
What happened?
Mr. Jones, I've appointed a lawyer for you. The lawyer is the person that you really need to discuss the facts of your case about, so the lawyer can assist you. It's not really much I can do at this stage because I don't have the officer here and I can't conduct a one-sided hearing.
Yeah, I just want everybody to understand as I was reading. I'm saying sorry for reading, but thank you, sir. Thank you.
You're welcome. You're welcome. You're free to go back.
Mr. Jones King.
Mr. Jones King, you're charged with one count of theft by receiving stolen property, and it's written as a felony. I've set a bond at $5,000. Do you believe you can post that bond?
Yes, sir.
You're gonna have a preliminary hearing date that's gonna be set for July 7th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
All right, you're free to go back.
Mr. Martin.
Okay, Mr. Martin, sir, you're charged with one count of possession of marijuana less than an ounce. The bond is set at $1,500. Do you believe you can post that bond?
Yes, sir.
You're gonna have a preliminary hearing date set for July 6th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, Mr. Martin. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back.
Mr. Peoples.
Mr. Peoples, sir, you're charged with one count of driving on a suspended license, one count of fleeing from a police officer, and one count of obstructing an officer. Your total bond is going to be set at $6,500. Do you believe you can post that bond?
Yes, sir.
You're going to have a preliminary hearing date set for July 6th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Peoples. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir. Not at all.
Okay, you're free to go back.
All right. Thank you, sir.
You're welcome.
Smith.
Give me 1 second, Mr. Smith. Okay, Mr. Smith, you've been charged with possession with intent to distribute marijuana, use or possession of drug-related objects, possession of a weapon during the commission of a crime, having looks like a non-functioning brake light, simple possession of a controlled substance. What is this? Hold on, I'm sorry. And possession with intent to distribute MDMA, and finally, possession of marijuana less than an ounce. So you're gonna have a total bond of $28,500. Do you believe you can post that bond?
Yes, sir.
You're gonna have a preliminary hearing date that's gonna be set for July 7th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, So I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay. Let's pause on the male side. I saw Deputy Cox. Mr. Florio, Mr. Smith, you're free to go back, sir. Mr. Florio.
Maybe I can get it right.
So, Mr. Florio, this may not sound like a compliment, but it is a compliment. When they told me that you were going to be on my calendar and who you're representing, I did not write a bond down because I normally will have to white it out and do something else. Your client, to my understanding, only has 3 prior arrests, including today. She's charged with theft by receiving stolen property, being in possession of a vehicle that returned as being carjacked out of the city of South Fulton, which is a concern of mine, and possession of or driving a vehicle that had a looks like it says removal or false identification number. Miss Esquipina, ma'am, I would normally speak to you directly, but you've taken advantage of the opportunity to hire a lawyer. So I'm going to be addressing my my questions to Mr. Florio. Please understand that anything you say here can be heard by everybody. It's not private. So don't say anything that you don't want the whole world to know. Do you understand that? Okay.
Yes.
So, Mr. Florio, I'll hear from you as it relates to your client.
Judge, may I make an inquiry of the court? Does the warrant have a date that the automobile was alleged to have been taken?
Let's see. I have a number that I think is a case number, and it looks like it's from 2018.
Okay. And Your Honor, the reason why I ask is I certainly don't want to make any misrepresentations to the court. But Ms. Esquipina's husband reached out to me last night. Essentially, they were driving home from Sam's Club. They were stopped by the Clayton County Sheriff's Office, I believe, in a roadblock. Her husband, Your Honor, was arrested in this car in DeKalb County, I believe in 2019. And we went through a similar issue with DeKalb County at the time because there were similar allegations made against her husband. Ultimately, through investigation by DeKalb County law enforcement, the car was actually returned back to Ms. Esquipina back in 2019. Candidly, Your Honor, I don't know what the issue is with this car. I don't know if there has been some sort of fraudulent activity conducted. I can only represent to the court that I do represent her husband it's a completely unrelated matter in DeKalb County in which he was arrested for suspended license and other offenses. And we did have this same conversation and discussion with DeKalb County, both the DeKalb County Police Department and also DeKalb County courts. And the issue we believed was resolved, and the automobile returned back to Ms. Esquipina years ago by DeKalb County Police. Obviously, that issue has not been resolved. You were actually able to provide more information to me than we were able to glean from DeKalb County at the time, because we did not know that there was an allegation of the car having been stolen out of the city of South Fulton and the allegations made. Ms. Esquipina's criminal history, as Your Honor indicated, is extremely limited. I represented her on the last matter. She successfully completed pretrial diversion with the district attorney's office, and the case was dismissed. The district attorney's office agreed to expunge or restrict the case on her record, and also agreed to seal the record. And so that has been done. I'm not familiar with that other arrest, but I suspect it would have been for a misdemeanor. Although I certainly could be wrong. I don't believe that Ms. Esquipina had knowledge that the automobile was stolen. There's nothing I think to indicate that in this case. No allegation of an obstruction where she would have either lied to the police or tried to flee on foot. No allegation of a fleeing and eluding where she would have tried to flee the stop by law enforcement. Certainly, it's something that we'll address with the district attorney's office immediately. And I believe we'll have a positive outcome as we did with DeKalb County. I would ask the court to take all those things into consideration in setting bond in this matter. Candidly though, I do believe that her family will be able to make bond today and is prepared to make bond. I've been in constant contact with her husband since last night, and I believe we will make bond once set today.
Okay, so essentially what I hear you saying is an innocent owner.
We believe so. That was where we found ourselves. I mean, literally, Judge, she was able to go to the impound lot in DeKalb County, and the automobile was released from DeKalb County Police to her back in 2019. And so I don't believe there was any knowledge either. I don't think anyone at that time understood kind of what was going on.
Okay, I can accept that because what I'm seeing here as it relates to the vehicle being returning from as a hit out of Tennessee as a felony vehicle. And I know at one point in DeKalb County and metropolitan Atlanta area, someone was obtaining false vehicle identification tags, and they were basically stealing cars, and they had a connection in Tennessee, and they could register the car in Tennessee. And you could be a person who purchased the car not knowing that the car had been stolen. So what I'm going to do is I'm going to set a bond. I'm gonna set a total bond of $7,000, $5,000 for the theft by receiving stolen, and also $2,000 for the having a vehicle with the altered VIN. As although it's charged as theft by receiving stolen property, I think it will be an issue of maybe a problem proving knew or should have known that the property was stolen. So I'll set it for 7,000 total. Preliminary hearing date to be set for July 7th at 8:30 in the morning. That date, of course, will get waived upon her bonding out, and she'll get a new court date in the mail. Do you have anything else for me, Mr.
No, sir, Your Honor. Thank you for setting bond this morning or this afternoon.
You're welcome. Ma'am, you're free to go back, and you're free to go, Mr. Florio.
Thank you, Your Honor. Have a good day, Judge.
You too.
Thank you, sir.
Thank you, Mr. Cox, Deputy Cox, for your assistance. Have a good day.
Sir, you as well, Your Honor.
Okay. Mr. Snipes, is it Snipes?
We went with Kowalski, sir. Kowalski.
Okay.
He got skipped. Kelsky. My apologies.
Oh, okay. All right, sir. You are charged with armed robbery, aggravated assault with a deadly weapon, theft by taking, possession of a firearm during the commission of a crime, reckless conduct, and driving on a suspended or revoked license. I am unable to set bond on the armed robbery charge at this time, so I am not going to set a bond on the other felonies. I'm required by law to set bond on the misdemeanor, so you're going to have a $5,000 bond set for reckless conduct and $1,500 bond set for driving on a suspended license. You're going to have a preliminary hearing date set for July 7th at 8:30 in the morning, and I'm setting a bond hearing date for July 9th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, Mr. Kelsky. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back.
Mr. Snipes?
Mr. Snipes, sir, you're charged with one count of improper solicitation of money on a roadway. You're going to have a bond set at $1,000. Do you believe you can post that bond, sir?
No, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. I am going to set a preliminary hearing date for July 6th at 8:30 in the morning. That date will get waived if you're able to bond out. I would also encourage you.
There's no way for me to make wrong. I'm like Job, everybody that I love has been taken from me.
Okay, so because this is a low-level charge, sir, you most likely will get placed on the next Monday calendar to have this resolved, and you will be released. Today is Thursday, so you may not be on this next calendar. You could, but this is something where it's just so low level that if you can't bond out, it's going to get dealt with at the earliest opportunity.
So there's not a possibility for a signature on our law?
No, sir.
Okay.
Okay, you're free to go back. Uh-oh, looks like it's frozen. Okay, tell me your name, sir.
Yes, my name is Warren Trump.
Mr. Turner?
Mr. Turner, sir, you're charged with one count of family violence, battery, and one count of terroristic threats. Your bond is going to be set at total bond at $8,000. Do you believe you can post that bond?
Yes, I try.
Okay. There's going to be a stay away provision on this bond to stay away from a Stephanie Ogans. Do you understand that? Your preliminary hearing date is going to be set for July 7th at 8:30 in the morning. That date will get waived upon your ability to bond out. Do you want me to see if you qualify for the appointment of a lawyer? Okay. Are you currently working, sir?
Yes, sir. I'm a part-time truck driver now, so I get disability.
Okay. All right. I'm going to find that you qualify, Mr. Turner. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir? Okay, you're free to go back.
Mr. Washington?
Harrison.
Mr. Washington, sir, you're charged with one count of robbery by sudden snatching. The way that this is written, it could be criminal trespass. I normally would not set a bond on a robbery charge, but the allegation basically is that you and your mother were in a dispute and you took her phone, which can be criminal trespass. I'm setting a $5,000 bond. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision on this bond to stay away from Stephanie Washington. Do you understand that?
No, because we live in the same house, and well, she's staying with me, and plus she wanted to drop the charges.
Okay, so she can contact the solicitor's office, and she can tell them her desires, and they will make a determination as to whether they are going to drop the charges or not. Okay, once the police are called, it kind of gets out of her hands. I'm sorry?
There wasn't no police involved. They just pulled me over.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for July 7th at 8:30 in the morning. And that date will get waived upon your bonding out. Now, I have to caution you, Mr. Washington, I don't know what happened, but the police were called. And I don't know if you know that or not, but the police were called. So I've given you a stay away provision. And if you are caught around your mother without that provision being lifted, you will get charged with aggravated stalking and you won't have a bond. And I say that to say this. I've had situations all the time where boyfriend, girlfriend gets into an argument. Girlfriend wants to drop the charges. I've placed a stay away provision on the boyfriend. They have a honeymoon period. They get back together. She gets angry again and she calls the police and he goes to jail for aggravated stalking. Because it doesn't matter that the girlfriend let him back in the house. The judge said don't go back as long as the condition is there. So I just get a vibe from you that may be a case, a situation, but I just want to make sure that you're adequately forewarned. Okay, sir, you're free to go back.
Judge, one last one, Mr. Harris.
We don't have Mr. Arnold. I was told that that was a second add-on.
I didn't have it.
Yeah. Okay.
What I'll do is while you're doing Harris, I'll run up the holding. And what is his name?
His last name is Arnold. It looks like his LE number is 0536076. I received his paperwork about 10 something, asking for him to be added on.
Okay, I'll run up the holding real quick and I'll go ahead and go get him real quick.
Well, can I get that LE number again?
0536076.
Okay.
You want to do it or?
Mr. Harrison, sir, you've been charged with reckless driving, obstruction of an officer, battery, hit and run, and running a red light. Your total bond is going to be set at $18,500. Do you believe you can post that bond? You're going to have a preliminary hearing date set for July 7th at 8:30 in the morning. Excuse me, that date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay. Are you currently working, Mr. Harrison? Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, you're free to go back, sir.
Deputy Barley went up there to see if we can get that inmate for you.
Okay, I'll stand by.
Thank you, sir. Huh? I mean, I know my judge. That's what I'm saying. I know our judges around here. That's why I'm just trying to get you guys in here and get you out. Yeah, a lot of you guys do because he's really straight. What I'm gonna.
Hey, Your Honor, I have Mr. Arnold.
Okay. Mr. Arnold, you've been added on to this first appearance calendar. First, do you have a lawyer? Have you hired a lawyer? Do you expect to have a lawyer for this hearing? You don't? Okay. The reason I ask is we did an add-on one day and the person had hired a lawyer. So I brought him back the next day. So if you've hired a lawyer for this, you're entitled to have the lawyer present. You've been charged with criminal damage to property. Criminal trespass damage to property. This is a misdemeanor. You're going to have a bond set at $3,000. Do you believe you can post that bond?
Yes.
Okay. The preliminary hearing date is going to be set for July 6th at 8:30 in the morning, but that date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. Give me 1 second. Are you currently employed, Mr. Arnold?
Yes, sir.
About how much do you make per hour or per month?
I make per hour $16.50.
Okay. Okay, so you do qualify, sir. I'm going to appoint a lawyer to represent you. And so the paperwork's going to get sent out today. Are you still residing at this Richfield Court address? Okay, so that's the information that I'll place on the form. Do you have any questions for me, sir?
No, sir. Yeah, is the bond posted for today?
It'll get posted today. The way that it works, you're the last person that I'm dealing with today. So I prepare all of the paperwork and then I send it over to the sheriff's department and they process it. And then once your bond is posted, you can get out. Now, the benefit of coming to this hearing is that you've been told your bond amount. So you can, when you're able to use a phone, you can call the any bonding company in the county. They'll give you a list of those bonding companies. Tell them your bond amount and your charges, and they will tell you what fee that they will charge. Now, you can also post your bond by just giving the total amount to the sheriff's department. They'll hold it until your case is resolved, and then they'll return that money to you. The final way that you can post a bond is by property. If you have property in the county that has a net equity at least 3 times the bond amount, you can put up that property as collateral for your bond. They'll place a lien on the property, and when your case is over, they'll take the lien off your property. Okay?
Is this the same thing? I can call a relative to bum me out? Is that the same thing?
Yes, sir. You can call a relative and that relative can do the same thing. So the relative can contact the bonding company, or the relative can bring the total amount of the bond down and give it to the sheriff's department. And they'll just be basically acting as a surety on your behalf.
Okay. Okay.
Any other questions, sir?
No more questions.
Okay, Mr. Arnold, you're free to go back.
Thank you.
Okay. All right. Thank you for your assistance today. Have a good